you all for being here. Staff, thank you so much for being here too. Conferees, thank you also for being here today and sitting out there in those hard seats and being patient. So I guess we'll go ahead and start with, we've got 3 bills to work today. Let's just go ahead and get Senate Bill 67 out of the way. So Carly, will you give us a brief explanation of Senate Bill 67?
Thank you, Mr. Chair. Substitute for Senate Bill 67 is the nurse anesthetist bill, allowing them to prescribe, procure, and administer drugs consistent with the nurse's education and qualifications.
Any questions of Carly? Seeing none? Very good. Committee, are there any discussion on this bill? Seeing none, I would entertain a motion to pass this bill. Representative Bueller.
Thank you, Mr. Chair. I move that we pass out Senate Bill, or substitute for Senate Bill 67 favorably for passage.
And a second? Second by Representative Blex. All in favor say aye.
Aye.
Opposed, same sign. No. Motion carries. Does anybody want their votes recorded? Seeing none, bill's passed. Okay, next let's do Senate Bill 29. Carly?
Thank you, Mr. Chair. Substitute for Senate Bill 29 removes the authorization for a county or joint board of health or local health officer to prohibit public gatherings when necessary for the control of infectious or contagious diseases.
Committee discussion. Questions for Carly? Seeing none, you're doing a great job of explaining these complicated bills. Committee discussion on Senate Bill 29. No. Representative Droege.
I'd like to offer an amendment.
Do I have a second? Second by Representative Bueller. Let's wait till we get it passed out.
But they weren't, we talked about them. I have this copy, but they just handed them out now.
Okay.
While we're passing out the amendment, Representative, would you care to explain your amendment?
This is an amendment to add the 72-hour review by a body that see a judge after they've been called for isolation. This bill doesn't impede the ability of the local health departments to protect the public, and it doesn't prevent local health departments from excluding or isolating or quarantining individuals or groups when it's warranted. It does limit their ability to do so unilaterally without accountability. And it does 2 things. It requires a minimal process documentation. If there's really a public health risk, then there should be a minimal documentation showing that warrants excluding, isolating, or quarantining individuals. Then there should be minimal showing that is required, proof. Allows the individuals subjected to exclusion, isolation, or quarantine the right to appeal as a protection against being wrongfully excluded, isolated, or quarantined. And no one, not even in the name of public health, should be unaccountable. These local health officers are not elected and therefore not accountable on the ballot. This bill simply allows Kansans due process and a right to appeal. I support Senate Bill 29 and I stand for questions.
Committee discussion on the amendment. Representative Reese.
Thank you, Mr. Chair. I understand that this is already in statute, the 72-hour.
I think that part of that is in the statutes, but it isn't the 72 hours, is it?
Carly or Jenna?
Thank you, Mr. Chair. Jenna Moyer, Revisor Statutes Office. So this language added in subsection D is taken from KSA 65-129C, and that is for when a local health officer or secretary orders an isolation or quarantine. It gives you that due process sort of rights. And then this would be added to KSA 65101. So if there would be a isolation or quarantine or exclusion order, like we heard about from the schools in 65122, this would cover that and give due process to any other type of order being issued under the authority of the secretary. So it's just that language that's currently in for isolation or quarantine orders, and it would expand it to the other orders that the secretary is able to do under, or that another officer could do under 65101 or 60 through 65129F.
Mr. Chair, can I ask another question? And actually, I see that KDHE is here. Can I ask KDHE a question about this?
I guess we can do that. It's kind of out of protocol, but
Good afternoon, Farah Ahmed, Kansas Department of Health and Environment. I am the state epidemiologist. I will try to answer your question.
My understanding was that the 72-hour was already in statute, and as the revisor said, it is, but I guess I don't totally understand what's in statute already with the 72 hours, and if you could clarify that, that would be helpful.
Sure. As the revisor pointed out, 65-129C specifically lays out all of the requirements of an isolation and quarantine order. You have to say, the time period that the person's under isolation and quarantine, where, all of those details. In that same statute, it does say that there is an appeal process. Anyone can appeal an isolation or quarantine order within 72 hours. And as far as any question about other types of orders that could be under the authority of the secretary or a local health officer, public health only sets out isolation and quarantine orders. The exemption or the other types, that was still a quarantine order that was in question.
Thank you. Thank you, Mr. Chair.
okay. Representative Blex.
Thank you, Mr. Chair, and this is probably a question for the reviser, and on line 5 on the top, I'm going back up to where it says, then such action shall not be taken without probable cause supported by oath or affirmation. Can you explain a little bit of the committee? I kind of understand the probable cause, but is that a notarized oath, affirmation? Just help me out there if you would, please.
Hang on just a minute. And just for clarification, where are you at on the bill? Oh, okay.
Yeah, up on the page. Be back up.
The back of page.
Back of page 1 on B line 5, that block that is
Okay.
inserted in there after state.
Got it. Committee, you know where we're at?
Thank you, Mr. Chair. Carly and I had to do some teamwork. So this language is taken from the Kansas Constitution in the Bill of Rights, Article 15, related to search and seizure. And so it would just be that language, the same to do a search on your home or to make an arrest. It would have to be probable cause with an oath or affirmation. And I don't believe that's required to be notarized. That's not a requirement that I'm familiar with.
Thank you for that. Thank you, Mr. Chair.
Very good. Committee, further discussion. Representative Droege.
I would just say this is to add a layer of accountability, and it requires a minimal showing probable cause that there's actually a confirmed case of potentially life-threatening problems. And this is also to make consistent language with 129C and 201.
Very good. Thank you for that. Representative Howe.
Thank you, Chair. This is a question for the reviser, I believe. So 65-101, it says the words in bold there, like health supervision, investigation of causes of disease, sickness and death, et cetera, et cetera. Is that directed at the Secretary of Health and Environment, or who is that? Who's going to be doing the investigation?
Thank you, Mr. Chair, Representative. So that is just the title of the statute. It does not have a legal interpretive effect. They are added on after the session by our office, just as a way to reference what is contained within that statute. And so that will not be in the bill. This is just the easiest way for us to put it into amendment form, is just copying it from our website where the name of the statute is there. So that bold head, that is just the caption of the statute.
Okay, thank you. So A on is already existing language, of course, as usual. So 1, 2, 3, 4, and 5, et cetera, is all existing language and falls under the Secretary of Health and Environment. Okay, thank you. Just wanted clarification.
Thank you for that. Committee questions, further discussion? Representative Bryce.
Thank you, Mr. Chair. I have a question for the reviser, please. I've gotten a little more confused, and without this amendment, the bill as written, would there be an appeal process, and how would that take place, and where would that appeal be to for isolation or quarantine for infectious disease? Thank you.
Thank you, Mr. Chair, Representative. So currently, there is a right to an appeal for orders issued under KSA 65-129C. So if your order is issued there, wait, there we go, and then it's subsection D of that statute. There we go, yeah. So if the local health officer or secretary requires an individual or a group of individuals to go and remain in a place of isolation or quarantine under 65-129B, 65-129C gives the procedure and the due process, as well as the language of D that allows for a hearing in district court contesting the isolation or quarantine. And so this would only apply to other orders issued under KSA 65-101 through 65-129F, and a party that's aggrieved by those actions.
Thank you, Mr. Chair. So as this bill under current, without amendment, would allow for an appeal, but it would not be a 72-hour time frame, or one thing I'm wanting to find out, I know there's kind of another layer here being put on for appeal. I don't know how much duplicative, if that's the right word, it is, duplicating it is of what would already be in effect. Thank you.
Thank you, Mr. Chair. The 72 hours is also currently in statute. The only new language is that last sentence, and this is taken from the amendments that you all did to KEMA in 2021, which would be KSA 48925, and that's that the court shall grant the request for relief unless the court finds such order is narrowly tailored to the purpose stated in the order and uses the least restrictive means to achieve such purpose. You fellow constitutional scholars may recognize this as a strict scrutiny requirement, which is a balancing test that the court uses in order to determine if something's constitutional or not. So it's taking that that rule of construction and putting it into this statute, saying that it has to withhold a strict scrutiny test, or else the court shall grant the relief. So that's the only additional thing that would be added related to isolation and quarantine orders.
Thank you, Mr. Chairman. So the strict scrutiny aspect of it would make it more difficult to reverse a quarantine or isolation because it'd be held to a higher standard?
Thank you, Mr. Chair. It's actually the opposite. So the burden then would be upon the state to prove that the order of isolation or quarantine is narrowly tailored and uses the least restrictive means to achieve the purpose stated in the order. So it would be easier to overturn an order of isolation or quarantine.
Representative Bueller.
I think, and I don't know if this is a question to the revisers or a statement, but as I recall the testimony from committee the other day, the language was to bring the two sections of law consistent and to make the language consistent throughout both the sections that we talked about here. And the underlying point that I heard is that by doing so, individual liberties and public health can coexist. Public health can still do their job, and we can still assure our citizens that their individual liberties won't be trampled through inconsistency in the language. So, thank you, Mr. Chair.
Representative Blex.
Thank you, Mr. Chair. As I read that the isolation and quarantine can still happen, and they have 3 days, that judge, and that the request for that hearing shall not stay or enjoin isolation. So it's not, that person's going to have to be in isolation for that 3-day period until that 72 hours is over, till a judge issues an opinion, which gives to me another right for that. It's not probably as fast as I'd like, but with the current system, that's probably pretty fast to be able to eliminate a 21-day issue of staying home. So that I think I'm correct in the way I was reading.
Janet. Oh,
So the request for the hearing, so just asking for the hearing, would not enjoin, meaning it would not put a stop to the isolation or quarantine order. That would have to happen upon the judge's order, and the hearing would have to be held within 72 hours, not necessarily the issuance of a ruling or an opinion that may take longer.
committee further discussion. Seeing none, Representative, you may move your motion or your amendment.
Thank you, Mr. Chairman. I'd like to make a couple of statements. That part of this is to make them innocent until proven guilty instead of kind of the other way around. And this bill doesn't hamper the health department's ability to respond to outbreaks. And we know that the health officials need flexibility, but there should always be accountability. By limiting their ability to unilaterally exclude, isolate, or quarantine, we're showing Kansans that their health and their freedom are both important. So with that, I close.
Very good. Committee, you've heard the motion. All in favor, say aye. Aye. Opposed? No. Motion carries. Would anybody like their no vote recorded? So the amendment is back on the bill. Committee further discussion. Seeing none, I would entertain a motion. Representative Rees.
I can't support this bill. I think there's some things about it that that just needs, it just needs more work to it. You know, for instance, you know, it does protect the child that may or may not have been exposed, but it doesn't protect other children, like the child sitting, you know, next to the child who said that they weren't exposed. And it doesn't protect all the other kids. And this is why isolation is needed. That's the protocol. And so I feel that's a problem here. There's also the piece of, if a family has chosen not to vaccinate their children, in every school district you sign a waiver, you know, whether it's for religious reasons or it's for health reasons, whatever it is, and you don't even have to say why, you sign a waiver. But within that waiver, it also states that that if the child is exposed, they still have to follow the protocol just like every other child in the classroom. So honestly, I don't know why we need this bill. The statute is already there, the protocols are already there to be followed. It feels, like school districts are following these. So at least for that, I won't be able to support this bill.
Representative Blex.
With all due respect, I mean, I appreciate the fellow representative's comments and, but we are still having 72 hours of quarantine and isolation. That would be able to send that kid home. And we all know as parents and grandparents that a lot of those symptoms may be over in 3 days. It may not be what we think it is, and it may not be as crazy, as can be. As far as the exposure, we can't ever really, I don't think, prevent that, because by the time we figure it out there's something there, it's probably already too late. And so I think this gives us another pathway. We're still all reeling from the impact of COVID and the shutting down and all that. And this isn't probably as far as some people would want, but at least it's a step. It makes that person issuing that quarantine order to think twice that, hey, I better be right, this better be good. And I may not want to say 21 days because I know now there's a judge who's going to look at that within 72 hours. So I think it gives another tool for those parents that want to have more control and feel like they was wrong during certainly the COVID epidemic. And I certainly seen a lot of cases, got a lot of reports from that. So I'm going to support it. I think it's a good step. It's probably not as much as some people want. If you read your emails, they can get pretty nasty at times on what they want, but I'm going to support it. Thank you.
Committee further discussion. Representative McDonald.
Thank you, Mr. Chair. I understand that we're coming off of COVID and a lot of emotions, but at the end of the day, I think our system probably works. It's unfortunate that it didn't work for the conferee who spoke about the 21-day issue with chickenpox, but I think there was a system in place, and if people followed the process as it should have been followed, this wouldn't be such an issue. Anything that is going to significantly limit the ability for our epidemiologists to significantly slow down the spread of infectious disease is something that I can't support. My own children's high school at Olathe Northwest has dealt with a tuberculosis outbreak in recent years, and I, as a parent, took the opinion that the epidemiologists weren't able to do enough to make me feel safe with my kid. So I think this is the laws that we have right now are probably a decent balance of both extremes. So I'm unfortunately not going to be able to support this as written today.
Very good. Thank you for that, committee. Representative Bueller.
Thank you, Mr. Chair. If I'm going to not digress a little bit, but I'm going to add some personal experience so you know where I'm coming from on this bill. I probably had more immunizations than anyone in this room, thanks to my 28 years in the Navy, including starting the anthrax vaccine, I think, 3 times. So I've had probably more shots than anybody in this room. Also in 2014, I was deployed to Kuwait when there was an Ebola outbreak in the continent of Africa. And for those of you who know about Ebola and the Defense Logistics Agency, all of the personal protective equipment and all of this stuff that comes from this government to that continent happened through the agency I was working for. So I take this stuff seriously. I don't take it lightly by any means, because in that day, in 2014, there were hundreds of people dying within 24 hours of exposure or whatever it was. But I do go back to, and maybe it is a little bit of from having to do Christmas outside of a nursing home with my mother and my mother-in-law, COVID, back in 2021, and I'll park that for now. But I get back to what our conferees talked about. And this statement, individual liberties and public health can coexist. There's nothing in this statute or this change as written that limits KDHE's authority to do its job. What it does allow is that matter of redress that was missing in this case, either through a technicality in the law or inconsistencies in our own language, and that's what I believe this does. It's a due process issue, which we all have as citizens of this state and of this country. So with all due respect, I filter this with my own personal background. I am a strong supporter of this, and I would urge the committee to support it as well. Thank you, Mr. Chair.
Representative Steens.
Thank you, Mr. Chair. And actually, the representative before me kind of pointed out something that I was going to ask. Because when I read this, it's saying concerning public health, and I know we're talking about the schools and things like that. So my understanding is, just so I have clarification on this, it still doesn't remove the quarantine. So if the KDHE says, if the parents sign a waiver in this school knowing, okay, if my child's has chickenpox, for instance, like we discussed here, they're still quarantined for that 21 days? Is that the current? Because I know there's only certain ones that are quarantined for a certain amount of times. I think there was like 2 on the list that I looked at.
Thank you, Mr. Chair. So I'll just read to you the statute.
Okay.
Farah
Just so I
may be
know,
able
'cause
to
I'm
talk
getting
more about the
confused.
different conditions, but the current statute is unchanged, KSA 65-122, and it states that it shall be the duty of the parent or guardian or the principal or person in charge of the school or child care facility to exclude therefrom any child or other person affected with a disease suspected of being infectious or contagious until expiration of the prescribed period of isolation or quarantine for the particular infectious or contagious disease. And that's unless you go to a doctor and they say you don't have the disease, you're good to go back to school. So that statute remains unchanged. This would give sort of an appeal right after the fact to appeal that order.
And that's for that 72 hours?
Correct.
Where that comes in. Okay, just so thank you so much.
And that would be for all orders of isolation, and this would be for all the orders of isolation or quarantine would be within 72 hours now.
Thank you.
Committee further discussion. Representative Weichel.
Thank you, Mr. Chair, and thanks for the discussion today. I'm not going to be supporting this bill, and I just want to voice why. So the point about individual liberties and public health, I think, is right. They totally can coexist, and they should coexist. But I think we need to also talk about the side of personal responsibility that comes into that, and choosing to be vaccinated or choosing to have your child vaccinated. And I think certain decisions come with certain consequences sometimes. And when we talk about public health, it's about both individual choices we make to help keep our neighbors and our community healthy and our own family, and then also the decisions of people who are kind of monitoring those things throughout the community. And then I think also, thinking back to the conversation we had when we heard the bill and some of the concerns raised around, judges making decisions about whether a quarantine order should stand or not, and just kind of some of the subjectiveness that I think can go between different courts on that and different people, and the lack of more medical professionals involved in that decision. So I think for those reasons, I just can't support it today.
Thank you for that. I might just add that there are a number of reasons why people don't get vaccinated, and some of it can be health-related and genetics and stuff like that, too. So it's not just a blanket type of deal that people can take vaccinations or want to. There may be other reasons why they don't. Representative McDonald. So, Representative Weichel, sorry.
Okay, yeah. No, I totally agree with that, Mr. Chair, and I didn't mean to imply that there weren't. And there's a lot of young babies who can't be vaccinated against certain things until they hit a certain age, which is why we need herd immunity and other things. So I recognize there's a lot of factors that go into that, and I wasn't trying to imply otherwise.
Thank you for that. Representative Blex.
Apologize for a third time or so. I can remember when I was growing up, I had chicken pox. And the neighbor had 6 kids, and guess what happened? The mother sent them over to us just so we could get, quote, herd immunity. Now, I didn't understand what that was. As I got up and pursued a field in biology, I kind of understood what immunity is. So there is some advantages, I guess. I mean, you don't want to lose anybody, but there is some advantages. How times has changed.
Yes, sir. Representative Berquist.
Thank you, Mr. Chair. I appreciate the intent of this bill. I believe it'll do moves in the direction I think are for the good of the people, and I will be voting for it. Thank you.
Any further discussion? Seeing none, all in favor say aye. I need a motion I need a motion. Representative Blex.
Thank you, Mr. Chair. I move that we move this Senate Bill 29 favorably out of committee as amended.
And a second. Representative Berquist. All in favor say aye. Aye. Opposed, same sign? No. Motion carries. Would you like your no votes recorded? Yes. Representative McDonald, Representative Orpeza, Representative Reeves, Representative Meyer, and Representative Weichel. Anybody else? Very good. Thank you, committee, for the robust discussion. I think that was very good. Bill's passed. Okay, moving right along. Now, I'm going to work Senate Bill or House Bill 2368. If you remember, committee, we heard this bill quite some time ago.
Thank you, Mr. Chair. House Bill 2368 would enact the Anesthesiologist Assistance Licensure Act, and it provides for the powers, duties, and function of the State Board of Healing Arts thereunder.
Committee, questions of Carly? Seeing none. Discussion committee. Representative Orpeza.
I'll start this time. Thank you, Mr. Chair. I thought about this bill. I considered this bill in great detail because I feel like we need to have access to care. But across the state of Kansas, I feel this bill will be detrimental to rural Kansas. It would not provide increased access for health care in rural Kansas. So that is why I'm unfortunately unable to support this bill in that regard. And saying that maybe in the future, if there's something that changes, maybe it'd be a possibility. But we've heard so many things done here about access to care and arranging different types of bills so we can keep our critical access hospitals open, that I feel like this would potentially cut off the CRNA's training opportunities to where they would unfortunately be unable to serve our rural Kansas hospitals and our rural Kansans in general. So that is kind of my rationale for not supporting this bill at this time. Thank you, Mr. Chair.
Very good. Thank you for that. Committee, I have an amendment. Do I have a second? Representative Blex? So while they're passing out this amendment, Representative Orpeza, you started the conversation for me. So this amendment states that anesthesiologist assistant programs or prospective training programs based in Kansas shall not accept new students prior to January 1st of 2033. The second part of that amendment, only students from the anesthesiologist training programs established before January 1st of 2020 in public universities in Kansas and Missouri may train in Kansas until January of 2028. So in much of the testimony that we heard when we heard this bill, that was a major issue with our CNRAs about the training slots. And so this moves it out, one of them 8 years and the other one 5 or 3. Discussion on the amendment. Representative Buehler.
Just a question. So what this effectively does is just open employment opportunities for those who are already possess the skill, correct?
Correct.
Okay, and allows no new ones in. Okay, thank you, Mr. Chair.
Representative Blex.
Thank you, Mr. Chair. I really, those of you who know me, I really struggle with this. Most of you, probably like me, has got a ton of emails, and I've been torn between how to vote on this. I've always supported that individual being able to practice under the scope of their education and their license and training. And certainly I'm in a rural district, and in this particular case, and for those of you that, and normally when I say something, I mean it. For those of you that I said something that you misinterpreted it or I changed, I apologize, because that rarely happens. But I have been bombarded with emails and the discussion and from the CRNAs and about concerns they have. I believe this amendment will alleviate a lot of those concerns. I appreciate that, your work in that, Mr. Chairman, and I think this is a start, because I think even though we've talked about this bill way back when, and I know they're tired of waiting, I've been down that road and been tired of waiting on other issues, but it may need a little more work, and I think this will give some of the people a little bit more confidence that, you know, they're not going to be pushed out, which, and I understand fully, it's going to be an urban thing. The AAs are going to be primarily in the urban, and the CRNAs are probably in the rural. But I have to go with my district, which is rural, so I'm going to support this amendment. Thank you.
Representative Bryce.
Thank you, Mr. Chairman. I will be supportive of this amendment. I think a lot of times when we deal with these turf battles, or so to speak, between two different groups, we're asked to kind of be the police and decide like we're the parent or something. And when one of the groups or both of the groups get together and they have a solid compromise like this, I think that is a very much a good sign of goodwill, and I'll be supportive of this amendment. Thank you.
Committee, further discussion on the amendment? Representative McDonald.
Thank you, Mr. Chair. I just have a clarifying question. This says only, like for current anesthesiologist assistant training programs in Kansas, you're putting some limitations. How many are there? How many current students? I don't really understand how this impacts what's happening right now as far as training goes in Kansas.
Carly, I'm not sure. I've heard the figure of 40 passed around, but I'm not entirely sure how many that is.
40 students? Is that what you're saying? Sorry.
What's that?
Are you saying 40 students in Kansas are currently being trained as anesthesiologist assistants?
The way I've heard it is it just affects 40 people. Now, I can't tell you in what context that is.
Okay. I guess if I could follow up, I'm not sure I can support something that would limit the scope of a training program, how many students they can have, or that sort of thing. I think that's pretty much out of our lane. I do appreciate the effort to try to meet in the middle. I've been kind of frustrated. We've all gotten bombarded with emails and many visits in our office. And I was misled by one side saying that there was a compromise reached when the other side said, no, we did no such compromise. So this whole thing gives me heartburn. I'm not a fan of this bill. In good faith, I'm sure you're trying to make it palatable, but I'm not in the business of making bad bills better. So with respect, I can't support your amendment.
Thank you for that. Representative Droege.
Thank you, Mr. Chairman. I appreciate the attempt to make this bill more palatable, but one of the first things I look at as the nurse anesthetist is the depth of the education and the ability to look at a patient with more than just superficial or knowledge of how many milligrams or how many cc's to give. I like the idea of somebody that's been educated in the medical field and come out and worked in the medical field and then gets their education. And by doing this, I don't think it's going to help the rural people, which would be my district, and they still can't work under a CRNA, and they still have to have an anesthesiologist. So like Representative Black said, it's going to be primarily urban. So, you know, that'll saying anyone can put a person to sleep, but it takes a professional to wake them back up. I always have to think about that. You have added some amendments here that make me think longer, but you're just kind of postponing it for a few years, and it's still going to be the same type of education unless the CAAs change it. Thank you.
Very good. Thank you for that. Representative Steens.
Thank you, Mr. Chair. I too have struggled, like some previous people here have talked about, and I just want to say both sides were very polite. I had excellent discussions with both sides, the CRNAs and the CAAs. And so I just want to thank everybody for being very cordial in the discussions and very professional. I think my biggest struggle right now is, you know, I'm more in an urban area, so we do have anesthesiologists and other, my understanding is it doesn't just have to be an anesthesiologist, it can be another like surgeon or some sort of type of doctor in that hospital. But maybe, please correct me if that's incorrect. But on the flip side of this, I think my struggle is I thought there was going to be more conversation between both sides. And I've heard, you know, there has been some, but it hasn't really gone very far. And I understand there's a lot of turf wars going on here. I get that. Trust me. I was a therapist. I get it. But on the flip side, I really was hoping that there would be more discussion. And so I think right now that's kind of where I'm laying just, you know, I think we can figure this out, but I just don't know that we're quite there. And so I probably will not be supporting this today. Thank you so much.
Thank you for that. Representative Weichel.
Thank you, Mr. Chair. I have a question about your amendment. Am I interpreting this correctly that it prevents CAAs from training in Kansas until January 1st of 2028? But it wouldn't prevent somebody who is licensed and completed their training in Missouri or another state that licenses CAAs from practicing. Is that right?
That's correct.
Okay.
And if you remember the discussion that we had when we conferenced this, that was a lot of the issue was around the training slots, the limited training slots that we had for folks to train. Representative Berquist.
Thank you, Mr. Chair. I've served on this committee since I joined the House at the beginning, and I have greatly appreciated the education I've gotten from people within the committee, people within the community, and people within the fields of expertise that we very often deal with. I have flipped around and struggled with this issue on this one for a couple of reasons. And the main reason is because I believe that our job is, as a role of the state, is to protect safe health care, but also in the regards of health care that seems to be lacking or we seem to be short of in the state, that we look for safe ways and help to allow for safe ways for more health care to happen that can't happen by instantly asking for a doctor to come out of the woodwork, because there's not doctors and nurses and other fields that can happen instantly. And we know that we also have to have people that are willing to become one and good at being one. And so there's that role that the people in the schools, they go through to qualify these people to go into these healthcare fields. I'm in favor of this amendment especially, but I committed to the intent of the bill because I believe that when a doctor tells me, an anesthesiologist tells me that utmost care is given in supervising an AA in the fields that they have, either in Missouri or wherever they've done it, I believe that we have to take them at their word, or we don't go under the knife to them, or we don't go under the anesthesiology to them. So there has to be a point of trust, and I believe that this has been a good intent. I've worked well with the CRNAs through the years, believing that they have a wonderful task to be done around the state, and they have still a great role that cannot be done by anybody else but them or an anesthesiologist if this bill passes, if my understanding is correct. So we don't have an absolute number on shortages or need for how many more practitioners in any field, but we do have an absolute picture every day that there's a need in the state for more health care. And I believe it can be done by practical measures rather than by extreme measures, such as Medicaid expansion. And because we don't go in that direction, we need to be at least responsible to provide for the alternative, and that is to find creative ways to be safe and effective in providing policy for people that are the experts. And we listen to those experts and then work from there. I'll be supporting this amendment for certain. Thank you very much.
Thank you. Representative Rivas.
Thank you, Mr. Chair. Yeah, one of my biggest concerns with this amendment is the limitation of the 2 states for training for Kansas and Missouri. This program is taught and is accredited in other states. So I think we may run into a problem if we're saying you can only be trained in those 2 states. So for that one reason alone, I wouldn't support this amendment. I do think that the other thing I've been hearing is I get conflicting information from both sides as far as that this is truly a compromise and been worked out. So I think we've got 2 groups that are meaning well, but still haven't quite come together on this issue. I'm also in a more rural area, and I have all CRNAs, and they've been very loud and proud about how they feel. I think they're willing to work with the AAs, but there's more work to do. They're not quite there.
Very good. Thank you for that. Representative Ruiz.
I concur with the previous representative and everything that he said. I'm very conflicted also. I've been on the fence, and I've been telling everyone that's been coming to visit me about that I've been on the fence. My gut reaction was, if it's not going to expand access in the rural and frontier areas of Kansas, then I can't support that. Honestly, I wish that the 2 groups would just come together and hash it out and figure out a way to not just coexist, but to expand services in our rural and frontier areas of Kansas. There has got to be some way to be able to do that. And if they need to have a school for anesthesiologist assistants and you put it out in Hayes, okay, then at least you're further out, going out west. So I can't support the bill. I really think it needs more work. I think the 2 groups need to come together and work something out that really would truly help our rural and frontier areas. Thank you, Mr. Chair.
Very good. Thank you. Representative McDonald.
Thank you, Mr. Chair, for letting me say a couple more things. I think to represent this as a compromise is inaccurate. I think that it's really hard for these 2 groups of people to come together to compromise because we have a finite amount of rooms where people get specific instruction on care. We have metropolitan areas that have acute care where they can help with serious cases that you might not run into as often in a rural place. Our hospitals in rural America are shutting down at a record pace, so we're not going to end up with more slots for training by 2033. I think we're just kicking the can down the road to have to worry about this in 2023 or 2028. This, to me, is not a solution. And while I do appreciate the thought about trying to get them in a room together and not let them out until they solve it, they aren't able to create magically some new OR opportunities for training. So I think that's kind of unfair, and I'm going to hush now. But I do appreciate the efforts that have been made on both sides to come and try to educate us and plead your cases. I don't see, and I try to be really creative, but I don't see how they could make everybody happy with this bill, and I think patients might suffer in the end.
Very good. Thank you for that. Committee, further discussion on the amendment. Representative Howe.
Thank you, Chair. I just wanted to comment that it is my understanding that there is no AA program or training programs in the state of Kansas right now. There are no AAs practicing in the state of Kansas right now. So this amendment, when it talks about prospective training programs or programs at all, there aren't any right now. So there are none at public universities in Kansas right now. So I just want to make sure that's clear to the committee.
Jenna?
Thank you, Mr. Chair. That matches with what I saw, but I did find the existence of a program at UMKC, which is in Kansas City, and so this would enable trainees from that program to do their clinicals at either, Missouri or Kansas.
Committee for Representative Berquist.
Question for the reviser, if I could, sir. And in the balloon amendment portion on the middle of the page, I think it's the second page, that says if such action is intended to exclude, isolate, quarantine, or otherwise, excuse me, I'm holding the wrong bill. I've got my good glasses on, just got the wrong page. Anesthesiologist assistant programs or prospective training programs. That's what refers to what might be in Kansas in the future. The prospective training programs, not stating that there is any in Kansas. Is that correct? Okay, thank you.
Mr. Chair, that is correct.
Okay, thank you.
Committee, further discussion on the amendment. Representative Turner.
Thank you, Mr. Chair. I've listened and also I've gone back and forth. I know we're on the amendment now, so I'll speak to the amendment. How about that? But this seems to be addressing this problem that I've heard from one side of that AAs coming into Kansas would somehow squeeze out opportunities for CNR. And I've asked questions about that in other states where this model has already been adopted, and I've not found it to be the case. So that will be my reason for voting no on the amendment. But thank you.
Committee, further discussion on the amendment. Seeing none, I'll move my amendment. All in favor, say aye. Aye. Opposed, same sign.
No.
Chairs in doubt, division. All in favor, say aye. Say aye or show. Yeah. All in favor, raise your right hand. 1, 2, 3, 4, 5, 6, 7. Amendment fails. Back on the bill. Further discussion, committee? Seeing none, all in favor say aye. Aye. What do I need? Boy, I get ahead of myself every time. I'd need a motion to pass out the bill. Representative Bryce.
Thank you, Mr. Chair. I move to pass out the bill. Thank you.
Yeah, not as amended. A second? Representative Bueller, seconds. Now, all in favor say aye. Aye. Opposed? No. Bill fails. Committee, I appreciate the spirited debate. These scope bills are not even scope bills. This is a licensing bill, just to be sure. But they are always difficult. And at some point in time, I think that there is a compromise out there that we can move on. Many of you, it's about access to care. And it gets harder every day and we need to do what we can to expand that. So thank you again. Tomorrow we will work another scope bill, a real scope bill. We'll hear it, sorry. And then we plan on working it on Thursday. Okay, with that, we're adjourned. Representative President.
I'm sorry, Mr. Chair, what bill number was that?
No.
Oh, 20. Thank you.
All right, thank you. We're adjourned.